volume of mobile phone you could get then was the Sony Walkmans, and how things have changed, where our phones are effectively our computers these days. He's also been a system designer, helping to create an ODR platform for the New York State Unified Court System. And he's also the John H. Farkey Jr. Chair for Empirical Studies and the Fellow for the National Center of Technology and Dispute Resolution. Those are eminent titles indeed. Apart from that, he works as a professor for the Equal Employment Opportunity Commission of the General Counsel Appellate Division in Washington, D.C. On behalf of that office, has participated in drafting the regulations and the interpretative guidance for the Americans with Disabilities Act. Without further ado, I will turn you over to Professor Larson.
Thank you for that introduction. As you know, we're coming off our Thanksgiving weekend, so I'm still recovering from our large turkey dinner. So if I seem a little sleepy, it's because I just had too much turkey. I have a PowerPoint presentation that I'd like to share with you. Just about there. Thank you for your patience. Okay, so yes, I have been involved with ODR since probably 1999. I've been writing about it, researching it, and as was mentioned, I have worked the last 5 years as a system designer for the New York State Unified Court System, and I'll be talking a little bit about that today. So ODR can expand or reduce access to justice. Could be a good thing, might not be such a great thing. So today I'd like to keep in mind a couple of things. This is an opportunity for us to reimagine justice, that we could do things with technology we never did before. And I don't think we need to be tied to our paradigms and our models about what justice looks like, and we can think creatively. We always talk about the digital divide. I think that the access to justice divide is even greater, and that's something that I'm going to talk about today. As we think about how we use technology for dispute resolution, we want to keep in mind that e-commerce is really different than public law, and we need to keep that in mind. And that, and then accessibility is a universal issue, and it's not just for persons with disabilities. So some of this is familiar to most of you. How can ODR improve access to justice? We know parties can't always come to court. They don't come to court for a variety of reasons. Maybe they feel shame, fear, don't have vacation time, just transportation issues, childcare, might be physically intimidated by the other party. They just don't want to be close to that person. Maybe because of disability, it's hard for them to move around. And so ODR can help with lots of these things. And I'm not sure I should be admitting everybody, but I keep admitting people into the room. So I hope I'm doing that properly.
Don't worry, David, we'll admit people so you don't get distracted.
Okay, thank you. So we have to think hard about what technology do you want to use or adopt for your ODR system? And importantly, what will be your standards and your ethical principles? And right off the bat, I'd like to refer you to the International Council for Online Dispute Resolution. There's a URL, just icodr.org. If you just use that, that'll get you there, and then you can navigate the site. But there are some standards that they have articulated, and they're expanded a little bit more than that list, but those are the titles of the standards, that your ODR processes should be accessible, accountable, competent, confidential, equal, fair, and impartial, neutral, legal, secure, and transparent. Right now, I'm working on a project as co-chair with two other individuals of the American Bar Association ODR Standards Task Force. I'm working with the National Center for Technology and Dispute Resolution and also ICODR. And we're trying to draft more detailed guidance or standards. We're not sure whether they'll be actually guidance or standards. We haven't decided that yet, but we're trying to flush out those very general terms that you see up on the screen and give a little more specificity than that. So as we think about technology, I think mediators always have a dirty little secret that mediators can manipulate sessions very easily. Maybe they do it consciously, maybe they do it unconsciously, but depending on how you time things and how you reframe issues, you can really influence the development of any kind of dispute resolution session. I think that when we bring technology in, the ability of the mediator to influence the dispute resolution process is even greater. One thing that most people are doing now is that when they use technology, they first introduce the parties to the technology. They say, here's the platform we're going to use. And they walk the people through the platform, whatever it is, the software. And as that's happening, something very subtle happens. All the people participating start to look at the neutral as the expert because they have all the answers. They're telling us how to use the platform. What should we do first? What should we do second? And now they're not so much a facilitator, they're now the answer person. And I'm not so sure it's that easy to make the transition from the person that has all the answers about technology to the person that's merely a facilitator. And I think that once you establish yourself as the answer person, that the parties may be looking to you to be much more evaluative in the process than you ever intended to be. And that's something you need to be conscious about. And I'd recommend that have somebody else introduce the technology, work with somebody else, have somebody else train the parties, introduce them to the technology, and then you stay the neutral, and then you're not wearing two different hats. Technology allows you to do all kinds of things. You can alter voices and form and timing. You could do all kinds of things if you wanted to. And I think we have to be very vigilant to make sure that neutrals are not abusing the technology. So I mentioned I worked at the New York State Unified Court System. We started with an online credit card debt collection project. It was not an ODR experiment. I think some places are using ODR first as a pilot to see if ODR even works. In New York, they had a huge problem with debt collection, and debtors weren't appearing in court, and they were suffering default judgments. And then that would mean their wages can be garnished, their property can be attached, their credit card reports are destroyed. So the feeling was we've got to make it easier for debtors to get involved in the justice system. And the thought was if we can get them engaged with technology, the default rate will go down and it'll increase the access to justice. And when I joined the project in October of 2016, I never thought I'd be still working with it. My first reaction was that's not the best case. It's too complicated. Credit card debt collection is very heavily regulated. We should start with something else, but because of that crisis in New York, that's where they wanted to start. So we designed a two-stage system, and that's one thing. If you're thinking about developing ODR, one way to approach it is to design first what could be called a expert system, where you provide just information before people even begin the dispute resolution process. They get some introduction to understanding the process, to how to get legal referrals, to financial resources and financial services that can help them decide how much money they have available for settlement. You want to have links to in-person court support, maybe some consumer protection information. One thing you want the parties to be available, and particularly the defendants, is that what are the most relevant legal defenses? So when you think about designing an ODR system, what you may want to do is have first this expert system that orients the parties, gives them information, because at least our experience is that many people who are doing ODR do it pro se. They're not represented by an attorney. So they come on by themselves, and they're not particularly well informed about the legal process or about legal rights. And if we can give them some information up front, that's very helpful. The idea is that, well, we're going to have technology on your side, just like it would be just like you would have an attorney at your side. After parties went through that process, which was mandatory, that orientation, education process, then we would have kind of a structured negotiation process where we tried to be as consumer protective as possible. We had links throughout the process to go to legal services. If people got confused or concerned, they could connect with legal services organizations. So the idea was, well, we're not going to put them in a blank space and let them say whatever they want and kind of go out of control and maybe go off the rails and start inflaming the situation. We want to give them more of a structured situation and present them with options that they can select. Well, it turned out there was surprising resistance. Our idea was we're going to build it from the bottom up. We're going to design the system, and then we will introduce it to the higher levels of the court system, and people will get on board because they'll be so impressed. As it turned out, one of my concerns was very real. There's a lot of regulation, and when people heard about ODR and credit card debt collection, they thought that this is terrible. It won't be fair to the debtors. We got to stop this. There was a organization in New York, the Civil Legal Advice and Resource Office, CLARO, that gives free legal advice about debt collection issues. The problem, and I think it's great if everybody could have an attorney at their side, but the reality is you can't. There's 100,000 debtors in New York a year that are getting called into court on credit card debt collection cases. Claro, over 10 years, could service about 7,000 or 5,000 people. So a tiny, tiny percentage. And it's true that when they go to court, they typically could win the case, but that still left the vast majority of people unrepresented who either weren't even appearing, or if they did appear, what would happen is they would meet the creditor outside the courtroom. Creditor would say, I have a great deal for you. If you agree to this, if you sign this agreement, you can discharge the debt on 50 cents on the dollar. So you owe $100. You sign the agreement, you only have to pay me $50. But the problem was every one of those agreements had language in there and said that if you are late with a payment, if you miss a payment, then the full amount of the debt becomes due. And so if you've got a $2,000 debt that you were going to spread over 2 years and you happen to miss one payment and you thought you're going to pay $1,000, the contract suddenly says that, ooh, you missed a payment. Now you owe $2,000. You signed the document that day. They took it in. It became a court order. The judge approved it. The case was resolved. And now they don't even have to go back to court. They've got a court order saying you don't owe $1,000. You actually owe $2,000. And so people were kind of getting deluded a little bit about the deals. And again, they're getting abused a little bit. But the credit card collection ODR system was stopped. And the lesson we learned from that, if you're building a system, is to be as transparent as possible. Reach out to everybody you think might be affected by this ODR process and make sure they understand what you're doing. And we tried to do that, and we thought we had done that. Anticipate there'll be conflicts and tensions. If you're looking at the photos, by the way, these are all photos of New York City. If you haven't been to New York City, that is the Chrysler Building, one of the famous buildings in New York City. So anticipate conflicts and tensions. You will be having to coordinate with state government policies and be aware of those. Another problem we had was that we designed the system. We were going to have an external vendor build a system. So we are going to put out a request for proposals for vendors to put in bids to build the system. And one of the problems was that the people that were criticizing, the organizations that were concerned about our design, New York didn't want to share the entire design with them because the feeling was if we give it to some people early before the request for proposals process begins, our process will be tainted. Some people will say that, oh, they had an advantage. They saw it before we saw it. So the feeling was, well, we can't release the entire design because that will prejudice this process, this bidding process. So then there was a misunderstanding about how much protection there was. And that was unfortunate, because I think if people had been able to see, the people that were critical had been able to see all the protections that were built in, they wouldn't have been as critical. But again, the feeling was, if we give them the entire design, then we have given it to some people and not to others. And when the time comes for public bidding, there'll be a feeling that the process was tainted. And that, again, caused some confusion. But probably the most important thing is, in terms of introducing an ODR system, is make it top down, not bottom up. If you're doing it with a court system, make sure that the people at the highest level of your court system are aware of what you're doing and they're on board with it. They are supporting it, because if your Supreme Court justices aren't on board, it probably is never going to go through. So build it from top down, not bottom up. So we moved down to small claims, goods and services, much more limited kinds of cases, $10,000 or less. We're not doing real property. We're not doing landlord-tenant, although because now a lot of landlord-tenant issues are coming up, we probably will open it up to that. We're not having multi-party actions. There's no suits against public agencies. We're being very careful to make sure that the parties don't have a history of domestic violence or orders of protection. At this point, we don't want one side having an attorney, one side not having an attorney. So we're saying no attorneys. And we're letting people initiate it in person. They can come into the clerk of court office and file a complaint, or they can do it online. New York, they're just beginning to schedule cases now. For the pandemic, they weren't. So what we had to do for our ODR system is just come up with an online settlement date to say that once you begin this ODR process, you have to finish it by this particular date. We decided to give people 2 months. When the court was assigning hearing dates, then there was a natural termination date to the ODR process, because the court would give a court date. And the idea was, if you don't finish ODR by this date, you're going to have to go to court and appear. That was some motivation for people. It's a little harder when you don't have that court date to keep people motivated and engaged, because they're not worried about going to court. But again, the court now is again begin to assign court dates, so that incentive for using ODR, I think, is coming back. But without that, we decided to say that, okay, once you start the process, you're going to have 2 months to work through it. So as I mentioned before, we have these hard opt-out questions. If you have an attorney, if there's a history of domestic violence, if there's an order of protection, you can't use the process, and it's got to be $10,000 or less. We also have soft opt-out questions. And I think these questions are really important if you're designing an ODR system. Ask people, are you comfortable saying what you think and standing up for what matters to you? Do you have difficulties accessing the internet, either with a computer or a smartphone? And your ODR system should be accessible on smartphones. Do you have challenges with reading or seeing text on a computer or a smartphone? Do you have difficulty, for us, reading or writing in English? Is there any other reason why it might be difficult for you to use ODR to try to resolve your case online before your online settlement date? So after every one of those questions, we ask the individuals, do you still want to continue with online dispute resolution? We give them the option, because even if they say, I have some difficulties accessing the internet, it may be true that I've found a way to work around it, because I can go to the public library, which is 1 block away, and I can do that. So even though people might be saying yes to these questions, we don't want to be too paternal and take that choice away from them. We'll let them make the choice, and we'll let them make the choice after every one of these questions. And the other party, typically the debtor or the creditor, can't see the answers. So the other party won't know your answers to these questions. Those will be kept confidential. We have animated videos. What's small claims court? What is ODR? I think those are very helpful. That's right at the beginning of the process. That's mandatory. People have to look at those. It was kind of fun to create those. I felt like we were in Hollywood and we worked with a kind of a company that specializes in that, and we did storyboards and designed the characters. So that actually was not only a good idea for the participants, but it was kind of fun to do. So this is the process for small claims that we have right now. We have blind bidding, where parties have the opportunity to submit demands and responses. So the creditor can put in information what they'd like to what they would wish to receive and what they're willing to receive. Kind of what's the ideal amount you'd like to get, and what are you willing to accept. And the debtor has the same opportunity. What would you like to pay? What are you willing to pay? And they go back and forth 3 times. If there's an overlap, the case can be automatically settled. We decided that we would look for overlaps on what are you willing to pay, not just what you wish to pay. And if we get that overlap, then the system will divide, we'll just split that payment and say, that's the amount you'll settle for. If you do reach an amount, if you can't agree on an amount, then we have a direct negotiation opportunity where you go back and forth in a structured negotiation and decide what's the number of payments, what's going to happen if there's a default, basically how much money will be in each payment. So basically you fill in all the terms of the agreement. So if you can agree on your amount and on your terms, the system will auto-populate a stipulation of settlement. If you can't agree, there's an opportunity to move on to request online mediation. So if you've started the ODR process and you hit a stopping point, you just can't get past it, an impasse, you can request mediation. And we've trained 2 mediation centers in New York that have worked with the court system before, who will join the process and serve as mediators. And we've set up, they have their own dashboard. They have a fair amount of control to do what they've always been doing. We're not taking away the way that they functioned in the past. So online dispute resolution. Well, when it comes to technology, I don't think we ever will go back. As we know, COVID-19 and the pandemic just keeps mutating. I know in South Africa, another mutation now is surfacing, and they'll keep surfacing around the world until we get rid of this virus, and that's very disturbing. So services may never be offered again face-to-face in some industries. And if that's true, there's a very real danger that vulnerable populations, including persons with disabilities, are going to be excluded from that new normal world. And this is everything. This is your ability to purchase products and food and pay your bills and engage in dispute resolution. As we think about making ODR accessible, I just encourage people not to conceptually segregate persons with disabilities, that accessibility is a universal issue. I'll say a few things about that. I'll talk a little bit about courts and legislation. This is kind of American focused, so I'll move a little more quickly. The value of it for you is that I think still there are helpful examples by looking at what other countries are doing and to see what the United States has done with the Americans with Disabilities Act and what Canada has done with their Ontarians with Disability Act. And there's legislation in Europe, as you know, in the EU, and they'll talk a little bit about best practices. So, everybody was rushing online during the pandemic. The whole goal is to get online as quickly as possible. And I'm not sure that everybody was thinking very clearly about or deeply about how to make certain that everything is designed so that it's accessible to everybody, including persons with disabilities. We want to make sure that whatever we're doing with ODR is actually increasing access to justice. It's not reducing access to justice. And it's not always easy to go back and fix it. It's better to do it right the first time. As we probably all know, Many people have disabilities. In the United States, the Center for Disease Control reports 1 in 4 Americans have disabilities. I think it's true that most of us either have or know somebody with a disability. So I don't think when we think about ODR accessibility, we should get too locked in to legal definitions about what's a disability according to the law, but we have to think more expansively about what's a disability and who's being excluded. Lots of research has been done about accessibility in current websites. It's discouraging when you look to see how many websites are not accessible. High percentages are inaccessible to persons that have perhaps vision impairments is one of the greatest problems. But also a lot of times there's video with audio, and if you have hearing impairments, you can't participate effectively. A lot of times there are clicks and manual things that have to be done that some people that if they have mobility issues and they simply can't do the clicking that's required. So we have a lot of work to do in making sure that our technology is accessible. It's just good business. If you're accessible, you'll have a bigger audience and you'll have more customers. And more people will be using your justice system. You'll definitely improve the lives of persons with disabilities. And if you need a legal motivation, if you are accessible, you can avoid lawsuits and bad press. So it's good design, or it's good business to use universal design. I guess my point is that you bring not only persons with disabilities into your audience. If you're using video captions, anybody who has noise in their environment will appreciate those captions. So it's not just for persons that have hearing impairments, it can help everybody. If you have limited bandwidth, and that's true all over the world. In the United States, we have great bandwidth in the cities, but you go out in the countryside, in the rural areas, some have very bad bandwidth. If you have a very clean, not cluttered ODR system, that'll be very much appreciated by people that have limited bandwidth. And if they're accessing your system on the phone, you want it to be very clean because they'll be looking at a very small screen. And you can't put a lot of text, you can't put a lot of graphics. And you want to make sure that that's very accessible. Accessibility is a human right. United Nations Convention on the Rights of Persons with Disabilities makes that clear. Persons with disabilities may not only be excluded from effective participation in dispute resolution, but from life in general in our new normal world. And that's one of my great concerns, is that as we become more dependent on technology, people who have difficulty accessing that technology will be pushed out of life in general. Article 9 of the convention says that we need to promote access for persons with disabilities to new information and communications, technologies and systems, including the internet. Article 13 ensures access to justice for persons with disabilities. So if you're not motivated by your desire to make sure persons with disabilities and other persons with limited access can participate, one other motivation might be liability. And in the United States, liability is a real thing. We have the Americans with Disabilities Act, and Title III is a section that says public accommodations need to be accessible. And there's an increasing number of cases being brought where people are being sued because their websites are not accessible. And that can be retailers, that can be service providers, that can be governments. In the United States, when we talk about disability, if you want the legal definition, it's a physical or mental impairment that substantially limits one or more major life activities of that person. So either if you have an impairment, if you have a record of that, and people are responding to that record and discriminating against you because of your history, or there are situations where you don't even have a record or have a disability, but people think you do. And because of that, they're discriminated against you. Number B and C are probably a little less likely to come into play when we're talking about ODR, but still possible. We're really focusing on situations where people have a physical or mental impairment. I was in Washington, as was mentioned, and worked on the Americans with Disabilities Act. And we did a lot in terms of preparing guidance and instructions and manuals. But the ADA, our Disability Act, was written before we went online. And so Title III says that public accommodations need to provide reasonable modifications unless they would fundamentally alter the nature of the business. So what's required? What does it mean to say that you've got to make reasonable modifications to your accommodation, to your business, to your website, to your ODR business, or your dispute resolution business, unless it would fundamentally alter the nature of that business? Well, when you go online, you get a lot of questions. Is a website even a public accommodation? It's virtual. Is it even covered by this kind of discrimination legislation? Our Department of Justice was going to write rules and regulations 11 years ago, but they never did. When it comes to designing an ODR system, there is something called the Web Content Accessibility Guidelines, WCAG. I think that's the gold standard. It's very detailed as to what you should do, what you could do when you create an ODR system. The Department of Justice in the United States was going to use that as a guide as to what people should be required to do to be in compliance with our disability legislation, but they just never went anywhere. They never completed that process. And then finally, 6 years ago, they kind of abandoned that process and they said, we're just not going to issue the rules. So what that means is that we don't have guidance for what it means to require, what is required when it comes to accessibility on the internet. I believe that all websites should be covered by the ADA. One thing that is settled is that if you have a physical location for whatever your business or service is, and then you also create a website, that website is regarded as merely an extension of your physical location, and that would be covered by the ADA. The bigger question is, what if you don't have any physical location at all and you only operate online? Right now, our courts in the United States are divided as to whether or not that website that has no association with a physical location should be covered by our Disability Act. My feeling is, well, of course it should be. All websites should be covered, regardless of whether they're attached to a physical location business. There was a challenge brought saying that, well, you know, the DOJ could not, Department of Justice, the United States could not come up with any rules for this. So that must mean that it's really difficult and confusing. And to apply this legislation to me on my website would be unconstitutional. It's so confusing. The Department of Justice couldn't write rules. And if it's too confusing for them, then it's got to be too confusing for me. So this legislation, because the Department of Justice couldn't write rules, it must mean that the legislation is bad and is unconstitutional and it's too vague and it shouldn't be applied to me. Court of Appeals decided, well, no. The act was always meant to be flexible. The fact that we don't have specific rules telling you what to do doesn't mean we can't enforce disability legislation. And all you need to be is flexible. You need to comply with our disability legislation with your technology, but you can be flexible. Well, great. You know, that's not the best guidance. And it's created lots of confusion. And what does it mean to be flexible in terms of complying with anti-discrimination legislation? As I mentioned, I was at the EOC headquarters when the ADA was passed. We did a lot of work and came up with very detailed guidance. So people know when it comes to a physical building, what they need to do. We just don't have that same kind of guidance for websites. And one of the things we're trying to do with our ADA ODR task force is get a little more specific about what people need to do when it comes to accessibility. In the United States, you can bring private lawsuits, but you can't get any money damages. You can recover attorney's fees. You can file with the U.S. Attorney General, and the United States Attorney General can get money damages, civil fines, but that's a volume problem. How many cases are they going to be able to file? To the degree there is any legal action going on in the United States regarding disability, it's typically happening at the state level, because there are some state statutes that do provide possible dollar damages. For example, in California, there's this thing called the UNRU Act that says each offense you have in your website when it's not accessible, you can have a maximum of 3 times what your actual damages are, and you can get attorney's fees, but it's capped at $4,000. So the point is that there are opportunities to bring lawsuits against persons that have websites that are not accessible in the United States, but still the ability is capped. It's limited. So you're seeing most of the action in only those states that actually have their own anti-discrimination legislation that covers websites. Before 2015, when the government was involved through the Department of Justice, they were getting settlements, and they were getting damages, and they were forcing people to comply with that web content accessibility guidelines. But then they stopped being active in the area. So that left it up to individuals who were surfing the internet to bring their own lawsuits as court cases. So you can see that when 2015, when the Department of Justice was involved, they were getting settlements with parties, but again, they stepped out of the picture. So to the degree that anyone wanted to challenge a website because they had accessibility concerns, they had to bring a lawsuit. And you can see that up until 2019, the lawsuits have been increasing. And to update it a little bit, here are some newer numbers. And if you just go over to the right side of the page and look at 2021, we can see now that we're getting over 4,195 lawsuits filed about digital inaccessibility. And that's just going to continue to increase. And those are just the court cases. That doesn't include demand letters, where people write letters to companies and website operators saying that you're not accessible. If you don't pay me a certain amount of money, I'm going to bring a lawsuit against you. Kind of demanding the settlement. Because the only monetary damage that's really available are attorney's fees, people are paying those settlements because they say that, well, since I don't really have to pay damages, but I might have to pay attorney's fees, the longer I drag this out, the higher the attorney's fees will be. So I better pay this off as soon as I can. So there's a little industry that's developed where people are initiating lawsuits or initiating demand letters, not necessarily lawsuits, threatening lawsuits, but sending demand letters saying that your website is not accessible. And they compare it with the web content accessibility guidelines. And they show examples of why it's not accessible. Then they demand a certain amount of money. The website operator says that, okay, I know I'm not in compliance, so if I get sued, I'll probably lose. So in order to keep my damages down, I'm just going to pay your demand. And then my attorney's fees will be very low. And that's a way to me to get out as soon as possible. That's just not a good way to run a legal system and a justice system. And that's why it's really important that we pay attention to accessibility on the front end. 70% of the accessibility sites, website cases are being filed in New York, which has one of these state statutes that allows damages. And what's happening is that only five law firms are filing almost all the cases. They're just going around and filing case after case after case, issuing demand letters, And people are paying those demand letters because they know they're not in compliance. And they know that unless they pay the demand letters right away, the costs are just going to go up. So we've got this little industry going right now of people demanding settlements and getting paid. 70, 90 lawsuits per week as of last September, just a couple months ago. You're getting cases filed in California, New York. Again, just a small group of firms filing the lawsuits, small group of plaintiffs. California, New York dominate as the places where cases are being filed. They focus on it's like a different industry at a time. Let's focus on colleges this time, medical companies the next time, automotive companies. So these law firms are just kind of moving through industries, going after everybody that has a website. Typically, they're suing for plaintiffs that are visually impaired or that are hearing impaired, they're blind or deaf. The same plaintiff is moving around, making the same claim against multiple defendants. A lot involve screen readers, involve allegations of not complying with the web content accessibility guidelines. And then if a company does have an accessibility policy, they challenge it that it isn't sufficient or it isn't effective. Widgets are creating lots of issues, and we're starting to see class actions, which then really accelerate damages. United States was going to pass some legislation. It was really bad legislation. It was really, if you looked at it objectively, it was more intended to protect defendants from lawsuits than to make sure that plaintiffs who had been prevented from accessing could get damages. It really was defense oriented. You've got these web content accessibility guidelines. The first iteration was 2.0. Well, they've advanced it, they've improved it since then. So I don't know why you would use the first draft of the accessibility guidelines as your standard, and why wouldn't you use 2.1? And there's 2.2 is being drafted. It's going to be finished around now. So the first thing is, why are you using a dated accessibility guideline standard for your legislation? It said you can't file a complaint until 90 days after written notice. Why should somebody have to wait 90 days to file a complaint and first provide written notice? Other plaintiffs don't have to do that. That seems like a real equal protection problem, that persons with disabilities have to wait to file lawsuits. Attorney General can sue for damages, but the legislation says the court has to consider whether there has been a good faith effort to comply. But I don't know why you should have to do that. The ADA legislation has been around since 1990. People know it's there. Why should it be a defense that, well, I tried to comply, but I didn't? I don't think a good faith effort to comply, given the length of time people have had to comply, should be a defense. If you go through the Attorney General, you have a private right of action, but what the legislation says, you have to plead with particularity every element of your claim. And anybody else who brings a lawsuit in the United States doesn't have to do that. All you have to do is to make allegations that plausibly suggest an entitlement to relief. So the fact that this legislation said that persons with disabilities have to plead with particularity every element of their claim, again, to me, seems like a straight out equal protection problem. They're treating those plaintiffs differently. So it wasn't enacted, but it's not dead. It's still kind of floating around, but it wasn't passed. I think it was terrible legislation. It's an example of what not to do. If you're considering legislation in your jurisdiction, look at that and don't do that. A better place to look would be Ontario, Canada. The Ontarians with Disabilities Act. They got involved, Ontario got involved early in the game in 2012. They started requiring compliance in their government websites. In 2012, they're using WCAG 2.0 level. So it's kind of ridiculous that in the United States, they would still be using that standard in brand new legislation. But if you're considering legislation in your jurisdiction, I would encourage you to look at the Ontarians with Disabilities Act. I think they've been a leader in terms of legislating accessibility. There's a European Accessibility Act. I haven't studied it. Maybe some of you have studied it more than me. I know it exists. I believe that you don't need compliance until June 28th, 2025. And you don't have to if there be a fundamental alteration or a disproportionate burden on your business. I don't understand why 2025 would be the deadline. That's so far off. That doesn't make any sense to me. There are directives in the European Union about disability accessibility. So I'm going to just finish up by talking about a few best practices. When you think about bringing your dispute resolution practice online, I think that you need to adopt a disability standard, and I encourage you to look at the Web Content Accessibility Guidelines that are meant to be a global standard. Having said that, it's not an easy read. You know, it's kind of technical. It'll take a little time to work your way through it, but it's just gonna be illuminating the things that they bring your attention to. So I think you need to adopt a disability standard. You should have some ODR principles and standards that you're relying on, and I refer you back to the IC ODR standards. And again, the American Bar Association is going to be providing much more detailed standards in the very near future. You should have a disability accessibility coordinator. If you're relying on outside vendors to provide a software platform for whatever you're doing, and a lot of people, and me included, I can't design from scratch my own platforms. I would have to rely on a software developer. You need to make sure that your requests for proposals actually have some accessibility requirements in them, so that your contracts and your requests for vendors need accessibility requirements. If nothing else, test your website. WAVE is something out of Utah State University. It's free. It's an extension you can put on your browser, and it will show what certain things on websites are not accessible. It's a really nice starting point. More importantly, probably I think the most important thing is, if you want to make sure that your website's accessible, use persons with disabilities as human testers. I mean, have somebody who's blind try to navigate your site with a screen reader. If you're using any kind of audio and you're using captions, see if those captions work. If you're not using captions, then you're probably, I think you're not accessible. There's a link to a color contrast checker that is very helpful. A lot of times people get enamored about different color combinations. The problem with some of those combinations is that they're problematic for persons with visual impairments. This contrast checker will really help with that. If you have people working with you, you want to train the staff how to use your website. In your court system, you certainly need to make sure that your clerk's offices understand how the website works, and you want to introduce it and get your judges familiar with it. And then somebody's got to be maintaining that website. Consult accessibility organizations. There's a group of them right there that can check your website and improve it and make sure it's accessible. Not all use human testers, so I would ask if they do. Put accessibility information on every page. If you're hiring people, have accessibility part of the job description, and make sure all stages of your ODR system are accessible. Last thing is, I'm working on a project on the board of directors of this RAE Corollary Initiative. This is really interesting. We're going to try and increase the diversity, equity, and inclusion in the selection of all neutrals, arbitrators, mediators, and other neutrals by encouraging a commitment to a pledge. And here's our pledge. We are hoping that dispute resolution organizations can pledge to include at least 30% of diverse neutrals on their roster lists. And what empirical research that has been done shows is that if your roster list has at least 30%, there's a significant increase in the likelihood that a diverse neutral will be selected. This is something that's just evolving right now. I think it's very exciting. The National Football League is committed to the same kind of thing when it comes to hiring their coaching staffs and their head coaches. And we're going to be pushing this idea in all kinds of different situations, but at least initially with the dispute resolution institutions and entities to see whether or not they will work hard to include 30% diverse neutrals on their roster lists. So I've got a book chapter in a book you may be familiar with, and I encourage you to look at it. The Online Dispute Resolution Theory and Practice book just came out. It's a new book. There's the editors. There's a link to my chapter. But again, I think a really nice resource and very helpful is the Online Dispute Resolution Theory and Practice text that's shown here. And this PowerPoint has a lot of information in it, and it's gonna be made available to all of you. So if you didn't get everything down, I don't see how you could have. You will get this PowerPoint. So thank you. There's my contact information. There's my author page, and I appreciate you listening to me today. Thank you.
David, thank you so much for such an enthralling talk. We have lots of questions. And Mirez, of course, has a hand up already, but there's also quite a lot of questions. And so I'm going to sort of exercise a little bit of leeway and say we're going to run 10 minutes late already. If we're going to at least try and answer any of those questions, and I'm sure people want to put those questions to you. I have questions of my own, actually, which let me sneak my own in as the moderator. I shouldn't really be doing this, but I'm going to do it anyway. Let me just sneak mine in and say, how do you see buying being encouraged? Because the most important thing on any ODR platform, especially with people with disability or people who are underprivileged, how do we see buying? I think linked to that question would be Mrs. Faraday's question about whether it has really, that buying has led to the default rates in New York being reduced. And then we can take the questions in the chat going forward. I know Mirez wants to say something, and is that a question? Or before I go on?
Sorry, Tunde, why don't I just suggest something? Why don't you take 4 or 5 questions and let David answer, just to save some time, so that gives us some mileage, and maybe we can cover so much. David, thank you so much.
Let me jump in and just so I don't get confused. Let me just respond to what about engagement, because I think that's a really important question. Right now we're in New York, that is the issue for us right now. Is engagement. We've got the platform up. What we're finding is that, the creditors, of course, the creditors, the claimants, the people that want to collect something, they're pretty willing to sign up. The problem is the other people who don't want to pay anything, they don't want to sign up. Why would they sign up? If they can keep running away, they'll never have to pay anything. So that's our big challenge. When we had the court date, when court dates were being scheduled, that was kind of the hammer that, if you don't do this, you're gonna have to appear physically in court. You're gonna have to take a day off work. You're gonna have to park in Manhattan. It's gonna cost you a fortune. Do technology, and that was a motivation. But right now we didn't have that. It was just like, try ODR and see how it works. And so we're having trouble getting people engaged. But now that court dates are being assigned again, I think that leverage is back, and that people may appreciate the fact that this is a lot easier than trying to get to court on the schedule, time, and date. And you may not have vacation days, maybe take a vacation day. Do you want to waste your vacation day doing this? Probably not. So we're sending out, when we send out our letter introducing people to the option of ODR, we're kind of explaining all that, saying that if you do this, you won't have to take vacation days. You'll be able to do it on your convenience because it's asynchronous, and you should try this. So, and we just sent that letter out last month. So we're hoping that increases our engagement. But that's a big challenge, and you really have to educate people that this is to their advantage, both for the claimants and for the respondents, that it's just going to be a lot easier. And you don't lose anything because all these systems, at least the ones we designed, at the end of it, if it doesn't work, you still can go back to court. So you haven't lost your ability to go to court. You want to assure people that that's still going to be there, but why don't you try this first? And you may find this works, and you may find it saves you time and money, and you may really be grateful you had the opportunity.
Thank you very much, David. I'm going to try and put Wangary's question and paraphrase it rather than just read it out, because his questions have to do with access of justice and whether to include access by the users to the tools and the platforms would in itself be classified as injustice if they don't have access. And I think what he was trying to say is that how do we get to simplify? You mentioned simplifying the access because of low bandwidth. People with low bandwidth can access the system unless it's simplified. How did you do that? How did you make it simpler for people who might not be as educated as us lawyers, or people who might just not have the same level of involvement in the legal system? How did you simplify it? Can you give us an indication of how that was done so that everybody, including practitioners who don't have the kind of experience some of us here on this platform can engage?
Yeah, so a couple things. One is that, again, I think it's really important that the system be accessible on mobile phones. That's how a lot of people access the internet now. Many people don't do much of anything. I have to confess, I do a great deal of my work on my phone. I don't do it on my computer. So the first thing is make it accessible on a mobile phone, which means that what you're going to do in terms of your text and your graphics have to be minimized because you've got that small screen. Now, we are working with an experienced commercial vendor, a company called Court Innovations in Matterhorn in the United States. And they've been doing this for a while now, and they're in a lot of court systems around the country. So they've put a lot of thought into doing this kind of concise, streamlined design to make sure that it is going to be accessible on a mobile phone. So to some degree, we're relying on their experience and expertise to do that. We haven't done it ourselves, but the one thing we can do is keep reminding them that whatever we do, and in New York, we've added a lot of things to it with our hard opt-outs and our soft opt-outs. Our system is probably, there's a great concern in New York about being very consumer protective. And so we've built some consumer protections into our platform that I'm not sure other jurisdictions are doing. But if we're going to do that, we have to make sure that's still accessible too. So we always have to make sure that whatever we're doing and requiring is something that people can access easily on limited bandwidth and on small screens.
Okay. Thank you very much for that. I will take one more of Wangary's questions about whether you're familiar with the kind of work in the area of community networks, whereby communities develop their own internet connectivity. So Wangari, is that as kind of standalone system you're talking about, or is it one that is just designed for specific community within their own community?
Hi, and thanks for just for picking that question. Professor, I really thank you. I just wanted to pop into the group that this was just a very easy session to follow on a very heavy topic, and I really thank you for it. So the community networks are when communities that are normally marginalized come together, the people come together, and then they develop their own internet connectivity. The reason I have picked on this is because I'm researching on the opportunity of having the community networks developed by the communities themselves, so that they can develop mediation service centers in their regions, then be able to access mediators from anywhere in the world. And then also if the courts are doing virtual courts, then the communities themselves have their own places they can access the internet. So Professor, I don't know if you have any inclination to such work that has been done. I'd be delighted to know more about it. Thank you.
Yeah, I have to confess I have not been involved with that, but that's one of the really interesting questions for the 21st century, is to what degree are court systems going to remain relevant, and to what degree are they going to be replaced? You know, because there's a possibility now of replacing court systems with the kinds of things that are being described. Community designed systems, because the technology lets us do that. So I think that court systems have to be aware of that, to know that this is happening, to know that court systems have been difficult to navigate. You needed an attorney to do it. Court systems now have to recognize that if we remain so difficult to navigate, people aren't going to use us. They're going to go to these community centers. That may not be a bad thing. Maybe that's a good thing. But to the degree that you believe that court systems provide certain levels of protection that may not be available in a community design system, then you might want to make sure your court system stays relevant. So I guess for that community system, I have all my same concerns about accessibility and also about imbalance. And I would just want to make sure that who's ever designing that system is being attentive to some of those things, to make sure that it is accessible to everybody in the community, to make sure there's no opportunity for any kind of intimidation or imbalance, that somebody's got to be kind of a watchdog for this. I think when people take control of their own lives and their own disputes, that's great. But I think somebody has to be vigilant to make certain that no one's being disadvantaged in that process.
Excellent. Mirez, your hand had been up for a while, and I'm already eating into people's windows, so I have 6 minutes left on the time I ask everybody for, past 1 hour. So Mirez, after you, please.
Actually, I was just clapping my hands, but since you're giving me the floor, Tunde, I would like to thank David for the excellent presentation, and I'm happy to have discovered about the work you've done in New York. I knew about it a little bit, David, but I didn't know about the details. That was really an excellent presentation. Thank you for the information. What I just wanted to say is that actually you can't get people using the system if the courts do not support, if the lawyers do not support, if everyone does not disseminate the information and encourage people to use it. So everyone has to contribute. And obviously some lawyers may think that they're losing business if the users are going online. And perhaps we need also to clarify to them that it's a different way of doing business potentially. So that was just a comment. And the other one was about the 30%, the pledge, David. I agree, we have to put a certain percentage in order to encourage people again and to give an incentive to increase the number of people of this category in the rosters, on the rosters. What I just wanted to share with you is that we've tried to do that with the pledge, the equal representation of arbitrators pledge, and we have decided not to use any pro rata simply because we were afraid, and we had an experience in this field, we were afraid that actually the roster or the list of arbitrators would include people, female arbitrators in this situation, who were not up to the job, and simply to get to that 30% that we wanted initially to include. So that was just a comment, but at the same time, giving a pro rata, a percentage to reach would perhaps be an incentive also to get people to think about more inclusion as actually is. Thanks, Tunde and David. That's all that I wanted to share with you.
Okay.
Thank you.
Thank you very much, Maurice. Does anybody have any other questions? Yeah. Mrs. Faraday, do you want to close us out today?
Okay, thank you very much, Tunde. Thank you, David. I want to especially say thank you to you. David, Maurice, and I are fellows at the NCTDR. So I learned a bit about the work of David, and Maurice is doing so much in the field of ODR also. Maurice is also, I want to also thank all the advisory board members that are on this call, Maurice, Juwon, Tunde, and all the others. I'm not sure I can see any other person. But most importantly, I think what we have seen, even from the conversations we had in the chat box, is that there is a need. And thank you, Andre, for coming on. I think you're still on. Andre is in South Africa. He's a very senior lawyer in South Africa, and he's very interested in seeing how technology can be used, of course, to improve access to justice. And it's so interesting that we talk about reimagining justice, and we're thinking about not necessarily taking justice out of the courts, but as Maurice and David has said, how we complement what the court system already has to improve and expand the opportunities, just like you, the great job that you're trying to do in the New York City. So once again, I want to say very big thank you to you, David. It's been such a pleasant 1 hour and excellent presentation, as always. Thank you. And thank you everyone for attending for your 1 hour. I think we're over that slot now. So I'll just let Tunde say bye-bye to all of us. Thank you all.
Thank you for the invitation.
Tunde, you are muted. You need to unmute yourself, Tunde.
Oh, I'd already spoken quite a lot. Thank you very much. David, thank you very much for coming on. I thank everybody for attending today, and hope to see you at the next one. Thank you. Have a good evening. I'm just waiting.
I think that was beautiful. What do you?
David?
Yes?
I will send you another Zoom link. I'll send you another Zoom link so we can get on the call for this. Yeah, because I asked you to stay on. So what I'll do is I'll send you a Zoom link so we can have a call afterwards. That's why I closed this one down.
Okay.
Okay, cheers.